Good evening, everyone. Hello and welcome to WISE's session tonight on divorce planning before, during, and after. I'm Angela Daly, WISE CEO. With our virtual format, we're thrilled to have participants from all over the country. So if you're not a WISE member, go to our website, sign up. It's free, and you'll hear about all of our fantastic programming. In 1997, a small but powerful group of women met in Orange County to put on an investment conference for women. They didn't know what to expect, but to their absolute amazement, it was a stunning success. More than 500 registered, and they knew they were onto something. Fast forward 25 years later, and WISE remains true to its original mission of financial empowerment for females of all ages and all socioeconomic backgrounds. We believe that if you manage your money better, you're going to have better outcomes, more opportunities, and the ability to fulfill your dreams. WISE works through organizations such as Girl Scouts, Girls Inc., and universities. And every year, we touch thousands with our financial empowerment message. Tonight's program is a very important one, but not a happy or pleasant one: divorce planning. When we all go to that altar, we believe that love is forever, but many marriages do not make it till death do us part. Some statistics show that there are over 800,000 divorces in America each year. Well, tonight, we have a fantastic panel to guide us all through this stressful and emotional period. We're going to be focusing on the financial part of this and the estate planning part, because if you don't pay attention to this, there can be some very bad outcomes and you could jeopardize your financial security. Kane Krause, who is a senior executive, a vice president at Dimensional Investment Advisors, a very prestigious investment firm, is going to be moderating our panel tonight and introduce you to our panelists. We have a 45-minute program, and then we're going to take questions. So anytime during the presentation, put your questions in the Q&A box, and we're going to take them at the end. We have a special thank you to Inspired Financial, who organized this event. Inspired Financial specializes in helping women through transition situations. And our community sponsor, UC Irvine Center for Investment and Wealth Management. WISE has a long history with each of these fantastic organizations. Now, as with any of our workshops, this is for educational purposes only. Before you act on anything, please consult with your advisors, your attorney, your CPA, and your investment advisor. So with that, I'm going to turn it over to Kane, and showtime.
Thank you, Angela. And hi, everyone. Thank you so much for joining today's WISE webcast on divorce planning, before, during, and after. As Angela said, my name is Kane Krause, and I head up client communities at Dimensional Fund Advisors. And I know that WISE's mission is to educate women and girls on investing and personal finance. And in parallel to that mission, at Dimensional, we have a thriving women and wealth community that works with financial advisors across the globe. And from that community, I know that the topic today on divorce planning affects so many women and men. We see advisors specializing in giving advice around divorce, and who are also working with attorneys that have specialized knowledge. So I really want to thank WISE for hosting today's session. Now, getting right to it, I want to introduce our great panel. Their bios are on the WISE website, and they were playing as we were leading up to it. But please help me welcome Janet Dockstetter from Dockstetter and Orliski, family law attorneys in Seal Beach. Curtis Kaiser from Kaiser Law Group. Curtis is an estate attorney in Long Beach, and also Maria Castillo Dominguez from Inspired Financial. She is a divorce financial planner in Huntington Beach and Miami. So welcome, panelists. I'm genuinely excited to be with all of you today for this discussion. And Janet, I'd like to start off with you on our first question. So to frame our discussion, can you tell us all about the divorce process at the highest level?
Well, if you're talking about the nuts and bolts of a divorce, the first thing you have to do once you decide you really want to have a divorce is you need to file the paperwork. And that means you would file a summons and a petition. When you file the summons and the petition, that's starting the case, you're getting a case number. But if you want to proceed forward with your case, you then have to serve the respondent. You serve the respondent, and you can do so one of two ways, either by personal service or by sending him a notice or her, a notice and acknowledgement of receipt. The personal service can be a little jarring for some people. So when people are getting along and they're cooperating with the divorce, a nicer way to go about it is to have somebody mail out the forms, the summons and the petition, with a notice and acknowledgement of receipt. And then the respondent can simply sign the form and send it back. And that will alert the court once it's filed that, in fact, the person has been served. Once the summons and petition is filed and served, you're then going to have to do your PDDs. There's really two things to be aware of. One is you're going to serve financial documents. That means, I said PDDs, that stands for preliminary declarations of disclosures. And those are an income and expense declaration and a schedule of assets and debts. So you're disclosing to the opposing party what all of your income is, all sources of income, and all of your assets. Those documents are signed under penalty of perjury. I caution you to really be careful when you sign those. If you mistakenly omit something such as digital currency, gold in a safe, and it is later discovered, you will be sanctioned most likely, and it could be very expensive for you. So after you do your preliminary declarations of disclosures and you serve them on the other side is also required to serve those on you. And once you have all that information, your case will begin. Once your case really begins, I say begins, but what I mean is you have the information you need to really start pushing forward. At that time, if you have a case that can be a bit complicated, or maybe you just need some more information, the next step is really the discovery phase. And that's where you ask questions. You can either take a deposition, you can serve interrogatories. There are a number of things you can do to acquire information from the other side. The intention, the objective of you and your attorney should be to really garner as much information as you can that will completely disclose the other side's income as well as all of their assets. And, for most people, they feel they have a handle on their spouse's income. And if you're a W-2, if you're a spouse with a W-2 employee, then perhaps it really is that easy. But oftentimes people are self-employed. And although your spouse might tell you that their income is perhaps $20,000 a month, once you do your discovery and you really get in there and you start looking at the books and you look at the accounting programs, you sometimes discover that the income is far more than the $20,000 that you had thought it was. And that can really give rise to a much greater support award. Perhaps there are assets there that you didn't know existed that can be discovered by going through the financial information that we obtain. So the discovery process is a really important step that you want to make sure you take care of going through. Once the discovery process is complete, once really you know that you have all the information you need, that you feel that you have a real handle, you and your attorney, on everything that you need to start settling the case, then you want to push forward and you want to try to start settling your case because it can be expensive to let divorces just drag out. So what that means is you get a negotiation letter out, a settlement letter out, and you start that dialogue. If that doesn't work, a really great next step is hiring a private judge to be a mediator. It's where you have somebody come in, or you can do it through the public courts. In fact, you sit down with the judge who's neutral. It's not the judge in your case. And both parties brief their sides, and that judge sits down with them and goes through what all the issues are and tries to find a fair solution where everybody walks away feeling equally unhappy. It might be the best way to say that. Nobody's really happy, but you feel like it was as fair as it can be. And during the negotiating phase or the mediation phase, nobody really is happy. I mean, you really feel that you've given a lot. But the thing to remember during that phase of your case is that you're avoiding litigation and you're ending your divorce sooner than it would otherwise be ended, because trial can take a long time to get to, and it can take a long time to get through. So if you can remember that the cost associated with trial, which can be in the tens of thousands of dollars, and really the cost or the benefit to your health, there's the cost factor there, I think. Sometimes compromising at the time of mediation at that settlement phase can be really the way to go. So if you get to mediation or your negotiations just fall flat and you really can't get anywhere, and you know litigation is really your only choice, the next step is really to set it for trial. And you'll set it for trial, and the judge will be the one to decide every issue in your case. That can be really scary for many people because I can't tell you what a judge is ever going to do. I can tell you what I think they'll do. But we all know, those of us who are in court a lot, that each courtroom, each judge has their own way of looking at things. And sometimes a judge that you think you know will surprise you on your specific case. So it's a gamble, but you get as prepared as you can and you go to trial and you let the court make that decision. If you get to that phase where you're at trial, you're proceeding to trial, then you might also really want to stop and talk to your attorney about the benefits of hiring a private judge. So when we think of trial, we think of going to court like you see in the court system, and you're in a public courthouse and the judge is on the bench, but it doesn't need to be that way. You actually can hire a private judge, and it can be really beneficial to do it. One, for efficiency, and two, surprisingly, even for cost sometimes. So private judges, they charge, they're expensive, and both parties will typically share the hourly rate of the judge. But the benefit is that you know that when you're setting up for trial, you're going to start that day. In fact, you'll start that morning, hopefully at the time that you've set the case to start. And you'll go all day. And then if you need more than one day, you'll go each day that you guys have assigned, hopefully right in a row. And you'll get through the case so much quicker than you really can through the public court system. And so it can make a lot of sense, and it can honestly be a cheaper way to go than going through the public court system, where sometimes we're set for trial at 8:30 in the morning, and our case will get called at 3:30 in the afternoon, and we're told that we're not going to get started. Or maybe the court will tell us they're going to give us 30 minutes that afternoon, and they'll have to set us for a second day of trial. And sometimes that second day of trial isn't for a couple of months out. And so as attorneys, we have to sit down with that file and prepare. We have to prepare again, which costs our clients a lot of money, and that can happen time and time again. So something for you guys to think about is just how you want to proceed, the tone you want to take, and who you want to hear the case.
Janet, as you were speaking, it just struck me how much there is to the whole process of divorce, how much there is to consider. Now, I'm sure there is a range, but can you give us a sense of how long the process of divorce takes?
Yeah, I mean, if it's a really easy case where it's very black and white, both parties are W-2 wage earners, maybe no children, no real assets, then at the very minimum, it's 6 months in California. That's the minimum before you can actually be divorced. But for most cases, they're a bit more complicated than that. And by the time you get through discovery and you actually get a trial date, you're typically looking at between 18 and 24 months, I would say.
Wow. So as I'm sure many of us who have dialed in today, who have signed up for the webcast today, know that it can take some time. Maria, I'd actually like to go to you next. Let's say, in your office, an existing client comes to you who says she wants to divorce her husband, and both of them are your clients. What guidance can you give her?
Well, this is a real problem because I have a duty of loyalty to each of them. So here I'm in a position of conflict. I cannot give the wife good advice if it will harm the husband. So any financial planning must be very neutral, like reviewing insurance coverages or rebalance the portfolio. I will probably avoid tax and estate planning, which could favor one spouse over the other. Sometimes I will tell the client that while the divorce is pending, our relationship will be what we call investment only, because some financial planning activities may violate the restraining orders, which Janet will talk about a little bit later. And depending how the conversation is going, I may describe to her the divorce process, as Janet just outlined for us. And I might also discuss the 3 methods of going through a divorce, which are litigation, mediation, and collaborative divorce. We don't have time to discuss this today, but that will be a choice that the couple needs to make.
Okay, so let's say that this is a new client. And it's let's say, is your answer different if it's a new client and only the wife is your client who's coming to you? So does that eliminate some of the conflicts?
Yes, in this case, my answer changes significantly because my only duty is to my client and I'm her advocate. So one of the things I need to do, I need to find out if either of them filed with the court yet. If they have not filed yet, she may be able to move some assets. I can give her advice on investments. If her portfolio is too risky, we can change the allocation to have less risk. On her life insurance, she can make her 3 children the beneficiaries and remove her husband. Now, if they have filed for divorce, then I have to be much more careful in my advice. If I think there should be any changes, I want to discuss it with her attorney before we do anything. And whether she has filed or is just thinking about divorce, I want her to be represented by an attorney. If she wants to empty a joint bank account or liquidate her portfolio, for example, I'm not going to give that advice. I don't want her in trouble and I don't want our firm in trouble.
Okay. So Janet, I'm going to go to you. Maria just talked about the importance of getting attorney advice. If Maria refers her client to you, what are you thinking about before you file or before she files for divorce? What's the difference before or during?
Well, it's interesting. I mean, the best time to see an attorney for family law is really before the parties have decided to divorce. So once somebody is toying with that idea, it really makes a lot of sense to sit down with the family law attorney and start to pre-plan. So for instance, one thing that I'm going to consider is the length of marriage. You know, in California, 10 years is a magic number for the length of marriage. It means once you hit 10 years, you're considered a long-term marriage. That means that the court has jurisdiction, the power to award support to be paid until the supported party remarries or the parties die or further order of the court. But the jurisdiction is really quite significant, whereas in a short-term marriage under 10 years, it's typically for half the length of the marriage. So depending on who's sitting in front of me, if I have a potential client who is the supported party, they're the ones who's going to need support, and they're at that 9-year mark, I might talk to them about staying committed to that marriage for another year. And if I have somebody in front of me who is the high wage earner, I'm going to talk to that person about filing maybe as quickly as they can so that we can be assured that it's going to be a short-term marriage rather than a long-term marriage. Other things to consider are any assets going to be acquired soon? You know, is a big bonus coming in? Are stocks going to be vested? Even though there might be a community property interest there anyway, if the party can wait for the other spouse's bonus to be paid out or for the stocks to be vested or some asset to be acquired, it just makes it cleaner. We won't have a pro rata share as the community interest, but it might be 100% community. Other things are like obtaining information that might be difficult to obtain once the spouse knows that you want to head down the road of a divorce. So financial documents, those are big. They disappear very quickly. If there's a prenup that benefits my client, and if it's somewhere in a drawer at the house, those are things that they want to make sure they're safeguarding before the word divorce really comes into play. Something else to consider are like appraisals. So if there's property that you think might disappear that you want to make sure you get valued while it's still in your hands, then do that. You know, if you have a valuable painting, get that appraised, or maybe even take possession of that. Don't liquidate it, but take possession of it so you know it's not going to just disappear. So there are some real things to think about when you're pre-planning a divorce. There's also some estate planning considerations, and I think really, Curtis, you're going to be great to talk about that. I can talk a bit about changing the beneficiaries of a life insurance policy, but there's so much more to that.
Thanks, Janet. I'm Curtis. I'm an estate planning attorney. And along the lines of what Janet just referred to as when you should seek legal advice from a family law attorney to potentially talk about whether you should get a divorce or how you should handle it, there's more that Janet can do at that time frame, and there's more that an estate planning attorney can do before a divorce petition is filed. So before a divorce petition is filed, most anything can be done. As Janet mentioned, beneficiaries on life insurance can be changed, beneficiaries on retirement accounts, annuities, pay on death accounts, possible adjustments to joint assets held in joint tenancy, changes to a existing separate property trust that one of Janet's clients may have had before the marriage that only has their separate property, creating a new power of attorney to say, I want someone other than my soon-to-be ex to manage my money if I'm incapacitated, someone other than my ex to take care of my healthcare decisions, and maybe even a new guardian domination if there's a real strife in the marriage and you no longer trust the soon-to-be ex-spouse with being the guardian of your child. Creating a trust, a lot more freedom to make decisions and move money before the ball actually starts rolling with the petition on the divorce. So Janet, take it back over from that point.
Well, I just really want to stress the importance of pre-planning. People don't really think about that, but it truly is important, and it can be important to get the estate planning attorney involved as well, and the financial person involved. I mean, it really, if you get your team involved early on, it can make a big difference in the outcome of the divorce. I think the other thing to consider, and what I haven't even said, is that when you file the petition for a divorce and the summons, ATRA is going to effect, which stands for automatic temporary restraining orders. And those really lock you down. It means that you're not supposed to gift away, transfer, deplete any assets. And so because your hands are tied at that point, you really, if you're going to take action, you really need to do it before you file your summons and your petition. Now, with that said, after you file a divorce, if the parties agree to do something, if they agree to liquidate an asset or to transfer money, then it isn't a problem. But a problem can arise when parties aren't communicating and they're not agreeing on those things. And so if there are strategic things to be done, it's vital to talk to the attorneys beforehand, in my opinion.
It's such an interesting discussion. Curtis, I want to go to you. Let's say, in lieu of what Janet just said, let's say the petition has been filed and the formal divorce proceedings are underway. Does all the estate planning come to a halt due to the restraining orders or the temporary restraining orders?
It doesn't come to a halt, but the universe of estate planning strategies or decisions that someone who's going through a divorce can make gets narrowed. So that's why ideally you're doing it ahead of time, but it's narrowed, but the door is not closed. And there's a family law section, 2040B, that says what you can still do on the estate planning side during the restraining order, during the period that the divorce is proceeding. And the theme around all of the things that you still can do is that at some point, a court is still going to have a chance to look at what you've done. That's kind of the theme running through it. So you can create a new will. When you create a will, those assets still go through probate court. So a court's still having a look, taking a look at it. You can cancel that separate property or revoke that separate property trust. If you have a joint living trust with your soon-to-be ex, it'll probably say you can only change or revoke that with the consent of both people. But you can remove a beneficiary designation. By removing the beneficiary designation, if you passed away, then it would go to court. You can create a trust with your new wishes, which is that the assets aren't going to go to your soon-to-be ex. You just can't transfer assets into that trust. But that trust could still govern how your assets would flow if something happened to you during pendency of a long divorce. So what Janet was mentioning, that even a straightforward divorce is likely to take a couple of years, and a higher net worth or bitterly contested divorce would regularly take 3 or 4 years. So if one of the spouses has a medical issue or both spouses are older, then for you or for your clients, you should have a heightened awareness of bringing the estate planning issues into the family law context.
That's interesting. You know, one of the things that we hear about a lot, you said clients that were older, is we do see trends on gray divorce. We see it in the news. We hear it at different conferences talking about divorce. And Janet, I want to go to you next. Curtis talked about, how while courts want to generally lock down all the finances when it comes to divorce, Curtis talked about some estate planning opportunities. So let's say a new client walks into your office for her first appointment. She's engaged you to represent her in the divorce. What are you thinking about the assets?
Well, I'm looking to each asset and discussing with the client whether it's community or separate. I mean, sometimes the clients themselves are confused as to whether it's community or separate. So we're establishing that. We're looking to title, if the title is in joint tenancy, for instance, as a community asset, let's say there's a home and that's being held as joint tenants. And I need to discuss with my client whether or not that's really truly how they want to hold title. Joint tenancy means that if somebody passes, the other person is going to inherit 100% of that asset. And that may not be what my client wants to have happen. But in determining that, some factors are going to come into play. We're going to look to, does the other side have any health issues? Do we suspect that it's possible that maybe, I hate to say it sounds morbid, but maybe the other side isn't going to live as long as my client. I mean, if that's a chance, that happens. And so if that's the case, then my client might want to hold on to joint tenancy. Another time is when my client is a young person and she's married or he's married a very elderly person. That happens. And when that happens, joint tenancy probably remains. But there are times where people want to sever the joint tenancy and become tenants in common, where they each own 50%. And that can become important, especially if my client is the one who might have children from another marriage, and they want to make sure that if they pass, that their children from the other relationship would also receive a share of their share of the asset. So we just have to look to all of the factors in terms of how are we going to characterize the asset? How is the asset titled? Do we want it to remain titled that way? And do we need to take any action to change titling and the outcome of what would happen if somebody were to pass pending a divorce?
I can see how we were really looking at areas of life and death and how that factors into the divorcing couple as well, no matter where they're at in their own individual life stage. But Janet, I want to actually change that perspective a little bit. Let's say there is no troubled marriage. As Angela kicked off, we hope that when people come together in a brand new marriage, that it's going to be a happy one. But let's say one of Maria's clients comes to her and say that they have a daughter who just got married, and they'd like to give a large gift, a generous gift for a down payment on something like a home. And maybe they're not so sure about the new son-in-law, and they want to protect the money. If in case the marriage fails, and because if the marriage did fail, then they could see the son-in-law potentially walking away with half of the gift. So if Maria calls you and asks about how her client can protect the gift, what guidance would you give her?
I think it's so interesting, and there's a couple of different things that I see routinely that I just really appreciate. So one is when parents want to give, let me just use the sum, $200,000. They want to give $200,000 toward the down payment on a home for I'll use their daughter, for their daughter and spouse. They aren't thinking about safeguarding that money oftentimes, but at the time of divorce, they wish they would have. So I think it's important for Maria and other financial planners to remember to talk to them about just that what if a divorce occurs. Are they really going to be okay having gifted that much money away? And if they're not, then what they should consider doing is writing a check just to their daughter for that $200,000. They need to keep a copy of that canceled check. And I would suggest that they save it in the cloud, something like a Dropbox, so it cannot be destroyed in any way. It would stay in the Dropbox until it's potentially needed. They would keep a copy of that. They would show that the funds they gave their daughter then went to the purchase of the home. So you're tracing the funds from mom and dad to the daughter as a separate property gift. And then you trace it from the daughter to the purchase of the home. And what you've now done is you've traced the funds that are separate property. So at the time of divorce, $200,000 off the top of that equity in the home would go back to the daughter, because those would be her separate property funds. And then the remaining equity would then be divided between the parties as community property. So I think that's a really great way to do it. A second way that I've seen frequently is when parents actually say, I'm going to give you this money, but then I'm going to go on title with you. And what that means is the parents will go on title with the two kids, I'll call them the two parties. And so when it comes time for a divorce, now what's happened is the community only owns 50% of the home. And so the spouse at most is going to get 25% of the home because the parents own 50%. And so that's a second way of safeguarding your interest in a home as a parent who's really has good intentions to give to the child and their spouse, but isn't really ready to just walk away from the gift if a divorce occurs.
Interesting stuff. Curtis, I want to bring you in with our hypothetical example and get your perspective from an estate planning perspective. If the parents, say, are your clients who are giving this generous gift to their daughter, what guidance would you give to them in this situation?
Well, I'm kind of with Janet. I'm going to say, hey, here's the way we could do it in the most protective way. If you don't do it in the most protective way, here's what's going to happen. So I'm meddling a little bit. And if they hear me and they don't want to protect, that's okay. But we need to have the conversation. And so once we have the conversation, if they're making a gift, they'll file a gift tax return, which is another piece of evidence that Janet would be looking for someday, along with the tracing as far as the intent of the parents. There's other ways that the parents could, other creative things that the parents could do, such as gift the $200,000 to a trust for the daughter that she can be in charge of. They can make a loan to the daughter, or a gift to the daughter and a loan to the couple. We can think all this through in a creative way, but generally with my clients, I'm going for the concept that, hey, the assets that you give to your daughter, great, those are for her. And if she's thriving and she and her spouse are doing wonderfully, that spouse will get some benefits from what the lifestyle that you have helped her achieve. But if her spouse is not being nice anymore, we're yanking them away. That's kind of the concept that we're going for. And so if the parents are willing to be thoughtful for that, going beyond the gift, just anytime they're giving assets to their daughter, either during their life or at their passing, I would like those assets to go in a trust for the benefit of their daughter that she is the trustee of. And if those assets are in a separate trust for her, she can manage and control them. And if her spouse is being nice, he or she gets to live there, use the pool, that sort of thing. But if they're not being nice, then it's not for them.
All right. Thanks, Curtis. And I think you and Janet have really underscored the importance of documenting the intent. And I think you guys have also really provided some great insights on gifting. Now, to everybody who's watching, we've got about 10-ish minutes left of our prepared comments and some of our prepared Q&A, but would love to encourage all of you to submit any Q&A into the Q&A section of the webcast. And while you're thinking of those great questions, Maria, I want to go to you because you've also been hearing a lot of these these do's and these don'ts. I can imagine how complicated this can get for you. How does this affect your financial planning process?
Yeah, whenever a client is in the process of a divorce, I always have with me a copy of the restraining orders in the client's file, so ready for me to access. If I'm referring a client to Janet, I know more about her finances than Janet does. And most likely, I know more about the finances that the client herself does. I know how their accounts are registered, how their house and vacation home are titled. She may have an IRA, a Roth IRA, a 401k plan. She may have inherited assets that are her separate property. Often this stuff it gets very confusing to the client and she has a busy life. So I can provide Janet fairly complete information and maybe some planning ideas because I know this woman's financial life. And I want to go back to the restraining orders. It's just good practice to review them before we implement any financial planning strategies. And when in question, we need to get approval from her attorney.
So that brings up, I think, an important issue, Maria. Can you give us an example of where a financial planner might unwittingly cause a violation of the restraining order?
Let's say that we have a wife in the middle of the divorce process. She hires Inspire Financial, and we move her S&P 500 fund over to our management. We tell her that 100% stocks allocation is too risky. So we sell that fund and we replace it with a mix of stocks, bonds, and cash. It reduces risk when you diversify. However, by selling that S&P 500 fund, I may have violated the restraining orders. Janet told us that the restraining order says that I cannot in any way dispose any property. And when I sold that S&P 500 fund, I dispose of property. So let me give you an example. We sell the S&P 500 fund. If I would have held it, let's say it will have returned 20% over the time of the divorce. And our new, less risky portfolio grew 12%. Now the husband says, you should have never sold that S&P 500 fund. I lost 8% because of what you did. His attorney wants the wife to reimburse the husband for the shortfall. Janet might say, you should have asked me first. And the wife looks at me and says, you should have not done that. You should pay him for the shortfall, not me.
I can see how that gets really tricky. I mean, I think as financial advisors, they think, and I know you think, Maria, is that you have a fiduciary duty to diversify, and yet you have to be cognizant of not violating the automatic restraining orders that come with the whole divorce process. What other planning activities come to mind?
Well, Curtis and Janet already mentioned estate planning ideas. So let me describe our main function in divorce planning. It falls usually into two categories. One is helping complete the two financial disclosures, and the second is helping the attorney with the property settlement. So the financial disclosures are the income and expense declaration and the statement of assets and liabilities. For the property settlement, we want to make sure that our client gets the best assets for her future financial success. And yes, California is a community property state, and let's say that the total value is split 50-50. So if the marital assets are $2 million, each party receives $1 million in value. It sounds equal, but that doesn't make them equal. So let me give you an example. First, we look at our future tax consequences. $100,000 IRA is not the same that $100,000 money market savings account, because the IRA has future taxes on it. So what we look at each asset. We look at the house, the retirement accounts, the real estate holdings, and see what future taxes might apply to each and every asset. Second, we look at the future cash flow. So $1 million portfolio might provide you with income and growth. $1 million home might be a money pit with mortgage, property taxes, and maintenance costs. So the bulk of our work is getting a tax-efficient property settlement and looking for future cash flow success for her.
I think you just really underscored the value that a financial planner who specializes in divorce can provide, looking at taxes, looking at growth, looking at all of the assets, and really understanding all the consequences. That said, we are getting close to time, so I want to move on to the after the divorce is final. So I'm going to throw this out to the panel. What happens next? And maybe Curtis, maybe we'll go to you first.
Okay, so most likely, despite what we talked about all of the planning that would be great to do, it's not necessarily the case that when Janet makes the suggestion or that Maria makes the suggestion that the client says, that sounds great. I've got the divorce going over here and I'll go talk to Curtis about the estate plan. Now that's ideal, but obviously it can be overwhelming to say the least. And so likely we're getting into a scenario where the estate plan that the now divorced client might have had, she has nothing. She has no will. She has the trust that she had with her spouse. Her spouse is the primary beneficiary. So it really needs a fresh start. California does have, to kind of avoid the negative consequences of someone who just got out of divorce and then passes away, does have an automatic revocation for things like life insurance policies and certain pay on death or annuity accounts that if the divorce has been finalized, I said if the divorce has been finalized, going back to why that needs to happen, planning needs to happen during the divorce. If someone passes away during the divorce, then it's not finalized, even if you were 3/4 of the way through it. So, but once the divorce is complete, California does have automatic revocations, but that doesn't cover ERISA governed plans such as 401k. The federal law preempts it. So the safer thing to do is for clients to work with their financial advisor to redo everything and to work with their estate planning attorney to get a new plan set up.
In our end, we're going to review every beneficiary designation. IRS, bank accounts, life insurance, annuities, 401k accounts. The 401k accounts and any pension plan for that matter, we need to immediately remove the husband as beneficiaries. Curtis talked about the automatic revocations, and as he mentioned, they do not apply to most pensions. We call those ERISA accounts. Whoever is listed as the beneficiary is the beneficiary. If the wife's trust says, my husband gets everything, and she dies without changing it, he gets nothing because of the automatic revocations. However, on a pension account beneficiary like a 401k, ERISA is a federal law, and the Supreme Court ruled that whoever is listed as beneficiary gets the money. And often also the wife was on the husband's health insurance. So when the divorce is final, she likely needs her own policy. She might pay for and temporarily keep her same benefits under COBRA, but she will need a long-term solution, and we will help her shop for that. And Curtis mentioned the need to update estate documents, so I don't need to repeat that.
Okay. All right, Janice, why don't you give us the final word on that? What else would you add to that? What else are you taking care of when you're finalizing the divorce, after the divorce issues, the final divorce decree? What's left for you?
Well, the big issue is oftentimes retirement plans. So I know Curtis and Maria are talking about changing the beneficiaries, but the plans themselves need to be divided most of the time. So what I mean is when one of the spouses has acquired an interest in a pension or a 401k, in order to divide those plans, something called a qualified domestic relations order needs to be prepared and filed. We hand that over to attorneys that specialize in only preparing those documents. We call them quadros for short. And so we have our quadro attorneys that we routinely rely on. And we really, when the judgment is done, we kind of hand it over to the quadro attorney to work with the parties to get that divided. But it's really important for the parties and the attorney to stay on top of that, because sometimes it can fall through the crack, and before you know it, it was never divided. So that's a very big issue to be aware of. Another issue to be aware of is changing title to the assets. So for instance, just because you were awarded the home doesn't mean it stops there. You want to have an interspousal transfer deed prepared and notarized and filed with the county recorder's office so that title is clean. Everyone knows who owns the home. Even with your cars, you want to change the title to the car if you were awarded a car. So really go through, see what your judgment allows for, and then do everything you need to do to make sure that what you were awarded is actually in your name, and what you weren't awarded, get your name off of it. You don't need the liability associated with it.
All right. Well, we are coming up to the top of the hour. We want to leave time for question, but I'm left with just the sense of the importance of having a good team of competent professionals on both the legal and the financial side. Mark, I know you've been monitoring questions throughout the presentation. I'm going to turn it over to you and let you and see what great questions we have for our panelists today.
Thank you, Kane, and thank you to the panelists. This has been terrific. So I'm going to try to get through all the questions, and if we don't, we're going to stop a couple minutes before the top of the hour so that Angela can bring us home. So most of these are going to be for Janet, no surprise. The first one came in: can a judge make the 6-month time frame? Can a private judge, if you hire a private judge, does that 6-month time frame, can you shorten that in any way?
No, it's a California law. It's a cooling off period, basically. It allows the parties time to file the documents, serve the documents, and then that 6 months to pass just to make sure that a divorce is really what you both want, or at least what one of you want.
Okay, very good. And question, you answered a little bit in your closing. This one came in: how are pensions handled in a divorce? And I'm going to give an example. Let's say the husband works for Southern California Edison. He has a pension that's going to be lifetime income, but maybe he's 50 years old and 10 years from retirement. How do you divide that?
Yeah, well, we call it the time rule. Basically, it's divided. The community property interest will be divided equally, but the important part is knowing what the community property interest is. So oftentimes you'll find an employee of Southern California Edison who was with the company 10 years prior to marriage. They had a 30-year marriage, and now they've been separated for 4 years. And so you have that separate property component that maybe the husband acquired prior to marriage and even after the date of separation. And that will be that employee's entirely separate property. But the portion that was acquired during marriage, that's community property, and that's going to be divided equally. When we say divided equally, there's going to be a formula prepared by that quadro attorney I spoke of, and they will present that formula to the plan. So when it comes time to pay out each month, the husband will receive his share and the wife will receive her 50% of the community interest only.
Okay, excellent. I'm going back to the part where we gifted our daughter $200,000, and we made sure it was separate property. We have the check, we stored it in Dropbox, etc. The question is, after a number of years, doesn't that just become community property? Isn't there a time period where it just gets, they might call it commingled or something?
There is no time period. No. So as long as you haven't waived your interest in writing for that separate property right to reimbursement, you maintain that right. Okay,
good.
Yeah.
So again, importance of documentation. And that's, I think,
Yeah.
I love that Dropbox example, because
Yeah.
if I gave to my daughter and all of a sudden I have that document in a box and we end up moving, you want to declutter yourself and get rid of boxes, and all of a sudden that paperwork's gone. And another thing that I might recommend is you have your financial advisor keep a copy of that check also and document it. And that's one of the things that we do.
Let me jump in, Mark. This is Curtis.
Yes.
Let me jump in with one way, because a prenuptial agreement, would handle that, would double handle that, but sometimes that's emotionally difficult. A way to kind of almost get the prenup for inherited or gifted assets is to gift them through a trust, or to encourage the recipient of the gift to then set up a separate property trust. And then it's pretty clear that the accounts weren't commingled and that it was the recipient's separate property trust.
Right. Very good. A question, kind of a general question, and this probably Janet, but then maybe Curtis might want to add something also. What about special needs issues? If you have a special needs child and the couple go through a divorce, and maybe we'll say the child is a minor, and then maybe address it if they're an adult.
Well, for me, all I can say that comes to mind is in regards to child support. So child support, the obligation to pay child support ends when a child is 18 and graduated high school. So if a child graduates high school and they're 17, you're on the hook to pay support until they're 18. Or if a child is 18 and in high school still, you're on the hook to pay until they graduate. But with a special needs child, there is a law that if that child cannot be self-sufficient because of their special needs, then the obligation to pay support for that child will continue. So that's how I see it in my area. I'm not quite sure otherwise what the questionnaire is looking for, but that's what affects us.
And I'll chime in with just saying that would raise the stakes and the importance of doing some advanced estate planning, unless it's one of the rare divorce situations where my client says to me, yes, I'm divorcing my spouse, but they are amazing with money. I completely trust them. And I bet my life that they will take proper care of my child. That happens pretty rarely. So in the other circumstances, it just raises the stakes to need to do planning in advance and early in the divorce process.
Yeah.
Thanks, Curtis. Okay, Janet, this one is a complicated one, and I kind of hesitate to even throw it out there, but I'm going to because the question was asked. Smith-Ostler percentage. Now, this is a situation where you have maybe a separate property house, but then they get married and the community, both of them, are making the house payment, making additions to the house, whatever else. So how is that percentage determined, and is there flexibility? Can it be changed?
Sorry, Mark, but I think there's some confusion. So it's Smith-Ostler is solely relevant to support, not to assets.
Oh, I must have made that was my ad-libbing, and I was totally off. So why don't you talk about Smith-Ostler for us?
Sure. So what happens, oftentimes we have people who work a lot of overtime, and we can't really gauge how much overtime they're going to work because it just vacillates. So rather than try and guess, which would be unfortunate to one person or the other when you get it wrong, we instead use a base income or some number that everybody feels comfortable using. So let's just say, for instance, somebody knows, I see it a lot with longshoremen, that I'll just use $10,000 as an example. They know they're going to make $10,000 a month, no problem. So we'll use that number for the base support amount. And let's just pretend that comes out with a let's say a $800 a month support award. I'm totally making this up, so that might not really jive, but just go with me. So let's just say that the supporting party has to pay $800 a month based upon their income. It would be more than that, but we'll just stick with the 800. So when they work overtime each month or each quarter, they have to do an accounting to the other spouse to show how much they have made in overtime, and then write a check to the spouse that makes up the difference. I haven't said that well. So what I mean to say is, based upon the income, the additional income earned by the higher wage earner, he's going to pay a percentage of that to the other spouse as additional child support or spousal support. Does that make sense how I've just worded that?
It does. Let me reframe the question. Oh yeah,
Sure.
I got Smith-Ostler and Moore Marsden mixed up, and I'm sure you heard me all over the place, and so I apologize. But we have a client, for example, in going through a divorce, and her husband receives board of directors fees, not super regularly, and so she does not get support on that. But every time he gets a board award, earns that, or some stock award, something like that, she gets a portion of it. And how do they calculate that?
Yeah, well, how they calculate it, for us, we use a program, and I am in the Orange County, LA area, and I rely on DissoMaster. DiscoMaster is one of those programs that are used to determine child support and temporary spousal support. And there's a magic little button up there that I hit that says reports. And it just lays out for me what percentage of income your client would have to pay based upon the amount he received. So it would just be a table, and it would tell us if he receives $5,000 that period, then whatever percentage the formula tells us he should pay is the additional support he'll pay to his spouse. I suppose I should know how they arrive at the formula, and I'm sorry that I can't give that to you. I've never had to memorize it because we just have the program available to us.
So, and then when a divorce goes final, I assume that a judge just makes a permanent order based on some kind of a percentage, or would they go
Yeah.
back to that DiscoMaster?
We'll use the base support, as I said, and then the additional report, the Osler-Smith or Smith-Osler report, as additional child support. And so that report will sometimes show you like 13.2% additional income needs to be paid for child support. And then it will go to 13.6, 13.8. So the attorneys will oftentimes just agree on a number that everybody knows they can rely upon rather than attach that report, because it's easy to do it that way. So instead, we'll just put in the judgment additional 13% or 14%.
Okay. We certainly got into the weeds as we
Yeah.
finished up. So it is time to throw it back to Angela and say thank you to Wise for giving us this opportunity. And Angela?
Coming on here. Well, I have to say that I am overwhelmed. That panel was absolutely fantastic. Kane, you did a fabulous job moderating, and all of the advice is just, it's overwhelming. So I think I'm going to reiterate what Kane said, that you need to talk to advisors, and preferably the sooner, the better. So Wise will put this on our website. If anybody wants to listen again, you can be able to do that. And we usually also put a transcript so that you can see and save this. But I think it's incredibly valuable advice. So thanks to everyone. Thanks to everyone who joined us today. We have a survey that we'd like you to take after this. We close this meeting. Just it really helps Wise to let us know how much you learned, and if you learned anything, and how valuable this was to us. And finally, our next event is in March, and it's part of our groundbreaking Tearing Down the Pink Wall series, which has a lot of educational components on investing and also some inspiration. So get you away from thinking about divorce. So thank you all very much, and hope to see you at the next event.